All right, good evening, Houston, and welcome to another episode of Reasonable Doubt, hosted by the Harris County Criminal Lawyers Association. I am not Murray. Murray is bald and ugly. I am black and handsome. Today, I have been joined by a great guest, Miss Sylvia Escobedo.
Hello.
So, we have an interesting show today, and we're going to talk about a few things, mostly dealing with cops, capital defense work, and politics. Let's get started. How are you doing today?
I'm good. How are you?
Ready? You got plans for Halloween?
I don't have any plans yet.
Nothing?
No.
Are you going to dress up?
I have no idea.
No idea.
My life is one day at a time.
Okay, well, so Halloween is coming up soon. The parties are next weekend. You're not
Yes.
going to dress up at all?
Honestly, I have no idea. This weekend, I have a 2-day swim meet for my son, and it's his birthday, so I'm just trying to get through this weekend.
Now, I know Luke.
Happy birthday, Luke.
Happy birthday, Luke. Swim meets happen during the daytime. Nighttime.
He is, like 2 days ago, he asked me if he could have like 20 of his friends over for his birthday after the swim meet on Saturday to watch UFC. So,
Okay, I support all that.
yes, I do
Swimming
too.
and UFC.
Yes,
All right.
outstanding.
Well, then, I hope you have a good time this weekend.
I will.
I plan on dressing up and hanging out and partying.
All right, invite me to the party.
You are invited. There you go.
Okay,
I'll invite you afterwards. I can't put it on the air because it's not my party,
sure.
but I will text you afterwards.
Awesome.
There we go. All right, so we're gonna talk about a few things here, kind of get it rolling. The first thing, which is kind of interesting, this Friday, Kamala Harris is coming to Houston, Texas, to, I guess, to stump for votes and that kind of stuff. She's gonna be in downtown Houston. What do you think?
I mean, that's not unusual for people to come campaign in Houston, Texas, one of the largest counties, one of the largest cities in Texas. So I will not be attending her.
Neither will I. One, because it's downtown, and
Right.
two, I don't like crowds.
Right.
And three, I don't like politics.
Correct.
So there you go.
I do not. I agree with you on all those things.
But Beyonce will be there. Do you like Beyonce?
I do like Beyonce.
She's a musician from Harris County, if anybody's curious. She has a wide catalog of a lot of music, apparently really popular amongst the young people.
I like her earlier music a lot more than her current stuff.
I agree. I actually can't name any really, I can probably name 5 Beyonce songs, but that's cool.
Yeah.
But good for Kamala. All right, so jokes aside. There have been some recent developments this past couple of weeks in dealing with death row and dealing with death
Yes.
capital work.
Yes.
And something I would say kind of startling happening out of Austin, Texas, dealing with a particular death row case.
Correct.
So before we get started on that case, let's talk about the death penalty in Texas. What is the death penalty?
What is the death penalty?
Yeah, what is it?
So if someone is tried for capital murder, the district attorney's office makes a decision whether or not they're going to try it as a non-death or a death penalty case. And if it's a death penalty case, then they have to convince a jury to sentence that person to death. And it's based on special issues. And depending on how that jury answers the special issues, then death may or may not be the sentence imposed on that particular capital murder defendant. Most of the capital murder cases in Harris County for the last few years are tried as non-death capitals. The death penalty was sought a lot more often many years ago, and obviously, when someone is sentenced to death, there are many years of appeals and writs going forward. So, I think I know which case you're talking about right now.
So let's rewind for a second. Let's talk about, you said special interests or things the jury
Special
must
issues.
and things the jury must decide. What are those special issues they must decide before you can get the death penalty in Texas?
They must decide that the defendant on trial is a future danger, and there is not sufficient mitigation to warrant life in prison as opposed to the death penalty.
So when we talk about capital defense work and we talk about the death penalty, what types of cases can a person receive the death penalty for?
If you intentionally or knowingly kill somebody in the course of a felony, such as an aggravated robbery. That's one of the most common that we see here in Harris County. You know, a robbery that's gone bad, a dope rip that's gone bad, those sort of things. Or if you're in the process of committing, you know, kidnapping, sexual assault, things like that, and you then intend to kill somebody, that is a capital offense. If you kill a child under a certain age, and that age has changed repeatedly
It has.
over the last several years. Or if you intentionally knowingly kill multiple people in the course of the commission of a felony offense. Those are some of the ways that the state can charge somebody for capital murder and seek the death penalty.
So if during the course of, let's say, aggravated robbery or kidnapping, a person dies, you can become eligible for the death penalty. Is that correct?
Yes.
If you kill a child under a certain age, multiple killings. You
Yes.
said multiple killing, more than two people. What about if you kill a cop?
Yes.
All right. Or how about a witness?
A witness?
Like to a crime, like to a witness to a crime, that kind of thing.
Actually, I can't answer that question.
So in Harris County, Texas, or in Texas, if a person, let's say, kills a child, that person can receive the death penalty.
Yes.
Has it happened before, in your opinion, in your knowledge?
Yes.
Do you know? And so let's talk about that particular case. There is a case that kind of hit the news recently that involved a man who was convicted of killing his child, shaken baby syndrome, and received the death penalty.
Correct.
Right? Let's rewind for a second. When I say shaken baby syndrome, what is that?
So, back when I was a prosecutor, I was a prosecutor from 1995 to 2009. Shaken baby syndrome is something that the experts would say this is a result. This death of this child is a result of shaken baby syndrome. Basically, that the defendant or the perpetrator shook the child so hard that the brain was literally moving back and forth inside of the skull, causing all sorts of trauma, or that it was shaken baby impact. That was another term that they used to use all the time, where they would say that, you know, the perpetrator took a child or a baby and maybe hit the head on an object. There were multiple prosecutions that were tried and secured and convictions being had based on the science back then, where the experts would come to court and testify this was a shaken baby syndrome case. But now we know that that is junk science,
Yes.
right? And so one of the big cases that's been in the news lately is he was on death row and was scheduled to be executed a couple days ago. And at the very last minute, he got a stay.
Right. So we're talking about the Robertson case.
Yes.
All right. And so in the Robertson case, he was a father, correct?
Yeah.
Now, when you say child, for shaken baby syndrome, generally speaking, how young of a child are we talking about, for the most part? I mean, we're not talking about a 14 or 15-year-old, correct?
No, typically, because I remember way back when the experts would, you know, hold a baby doll, you know, as an demonstrative aid in a trial, okay? A baby doll,
Right.
this big, and hold it and shake it in front of the jury. The expert would do that to show how hard that person had to shake that baby.
And the idea in those prosecutions, if I'm wrong, let me know, was generally that a parent was so upset at the child, maybe the child wasn't sleeping or the baby was colicky or whatever, that out of a fit of anger,
Yes.
they would kind of take their baby, and usually it was a baby,
Yes.
and just like, oh, please go to sleep, and shake the baby,
Yes.
Which would cause the brain in the cranial cavity to go back and forth, which would then, of course, bruise the brain, cause seizures of some sort, and eventually the baby would die.
Right.
Is that correct?
Yes.
And now you said that that was junk science. What do you mean by, generally speaking, junk science? And then we're going to narrow it down to Robert Robertson in his case and how this all developed and what ended up happening.
Now we call it junk science, but many years ago, it was allegedly confirmed in science. Right. And that is what the experts would testify to. The doctors at the hospital that were specialists in shaken baby syndrome and child abuse. And they would come to court and they would testify, this is shaken baby case. But here we are today, and all of that has sort of been debunked. And so now there are no, there is no foundation for, quote, shaken baby syndrome. Right. But there are a lot of people that were convicted under that theory and convicted under the testimony of those doctors that has now been essentially reversed.
So Mr. Robertson was one of those persons that was convicted,
yes.
Right? And he had a baby that apparently was sick with a myriad of diseases or,
yes.
or issues. Mm-hmm. And he would take his child from home to the doctor back and forth, like, my baby's sick and help
right.
me out here. My baby is not doing well and help me out here. And at some point in time, his baby passed away.
Right.
All right. And they developed a theory that Mr. Robertson shook his baby to death. Is that correct?
Yes. Right. That's my understanding.
And he was convicted and he's been on death row. Is that right?
Yes. He was supposed to be executed a few days ago.
All right. And so when we talk about executions in Texas, we're going to just jump over the trial and the appeal and whatever happened. What can stop an execution in Texas?
Well, basically they need to get a stay from Supreme Court, Court of Appeals. Sometimes the governor gets involved. There are different avenues. This was a very last-minute stay. I know that many of us who do capital litigation were on pins and needles waiting to see whether or not right. his execution was going to be stayed because of the shaken baby syndrome issue. I believe also there was an autism issue. Mm-hmm. So there was a multitude of issues, but you know, it happens like a few hours before the person, in this case, Mr. Robertson, was supposed to be executed.
So a person, when they're on death row, does it happen immediately, or is it quick, or does it take a long time? How long do you believe someone stays on death row before today's their day?
I believe that they typically stay on death row for a few decades.
Decades?
Yes.
So you're talking about 10 to 20 years?
Yes.
Wow. All right, so Mr. Robertson has been in prison for a period of time.
Yes.
You would guesstimate between 10 and 20 years?
Yes, I can't speak specifically.
Right.
I haven't looked at the record in terms of when his conviction and his sentence was imposed. But typically death row cases, unless the defendant waives all of his appeals and his writs going forward and just wants to be executed, it's a very, very lengthy process, very expensive process for the state of Texas. It can be, like I said, 10, 20 years, decades.
So, and you said a person can waive appeals. Assuming they do not waive their appeals, you go to trial. Mm-hmm. How long does a trial for a death penalty case last? How long does that trial last, give or take?
If it's a death penalty case, well, jury selection alone probably is going to last you at least a month.
Wow.
If not longer. And then the trial, I would assume, is going to take at least another month. You know, even if they prove up the case in chief, meaning the actual incident, they might do that in a week or two. But then they have to prove up, the state has to attempt to convince the jury that this person needs to be executed. So that's when they prove up all of the additional punishment evidence. So it can be several months that it takes to try a death penalty capital.
So a death penalty capital case can have almost multiple trials within one trial.
Absolutely.
The actual trial and then punishment trial, which could be anything.
Correct.
And so in this case, Mr. Robertson had his actual trial, and he was found guilty of capital murder. And then he had his punishment trial, and the jury decided to give him death penalty.
Yeah.
Right. All right. So now he is on death row, and you mentioned appeals. What kind of appeals can a person typically expect if they're on the death row?
There are multiple appeals, and then there's something different. That's the writ of habeas corpus. Once the appeals have been exhausted, then they go through the writ process. And sometimes down the road, it could be several years later, new evidence might develop that shows that this person was actually innocent. And that's when a writ attorney would file a writ of habeas corpus. So the appellate process is more so based on errors in the actual trial, and then the writ process is things that come up after the fact.
So in this case, Mr. Robertson presumably exhausted all of his appeals. His trial was deemed okay. And as you said, junk science later confirmed that potentially maybe his child was not shaken to death, but died from natural causes or something like that, right? And so through a writ, he gets a chance at a new trial. Or what? Now we're getting to the big stuff here. What happened in Austin, Texas, or what happened recently that kind of got him a stay of execution, at least for a short period?
I'm not sure of the exact procedure. I do know that earlier this week I was watching the committee hearings that were taking place in Texas. I don't know if you had an opportunity to see that.
I have not.
Judge Elsa Alcala, who was on the Court of Appeals, she testified very well. And she spoke about the entire process in terms of why we needed to revisit this particular case. And she was on the Court of Criminal Appeals, or the Court of Appeals in Texas, so she was able to explain to the lawmakers things that we could change going forward so that we don't repeat this outcome.
Right.
Interestingly enough, in that hearing that I watched, Dr. Phil testified.
Dr. Phil is in like
Yes.
a celebrity,
Yes.
like the Oprah Winfrey kind of
Correct.
psychologist testified? Okay.
John Grisham testified because, the author, the famous author, he used to write a bunch of crime fiction novels, and some years ago he got involved in some cases involving defendants who were actually innocent, and he started writing about those as well. So he testified. I didn't get to watch the entire hearing, but those were the three witnesses that I did watch, and it was incredibly interesting.
So when we talk about Mr. Robertson's case,
Yes.
it's one that deals with actual innocence versus some sort of trial error. Is that correct?
Correct.
And when you say actual innocent, this might sound silly, but like, what does it mean to be actually innocent of capital murder death?
Well, another thing that I did watch in this committee hearing, they called one of the jurors from his actual trial, and she testified very heartfully and very honestly, in my opinion. And she discussed how they convicted him because his defense attorney conceded that it was a shaken baby case, a shaken baby syndrome case. So he conceded that. And she's like, that's all that was discussed. Is this a shaken baby case? Yes, it is. Okay, we have no choice but to convict him. And, fast forward all these years, and she was there to testify at the committee, and they asked her multiple questions. Was there any other evidence that he sexually abused this child, injured this child, did anything else to cause this child's death? And they talked about, medical records and things like that. And she's like, no, the only thing the jury considered was the fact that they said this was a shaken baby case. The defense attorney at the time conceded in trial it was a shaken baby syndrome case.
And it's not.
And that was it.
And so now fast forward to kind of, I guess, today or last week, the science has kind of shown that maybe this wasn't a shaken baby case. This baby had illnesses.
Right.
And had other issues
Right.
that could have led to this baby's unfortunate death.
Right.
Correct? And those illnesses and issues would have explained why this baby died the way the baby died.
Potentially, for sure.
Right.
Yes.
And that would have been important to a jury and to a trial.
Yes.
So now we have, I guess, a writ which has brought these issues forth. And in order to stay the execution, the Court of Criminal Appeals or the Supreme Court of the United States, they didn't necessarily stop it. They just kind of subpoenaed him, right? They did something different procedurally to stop the execution.
They did. And at one point it appeared as though, well, the media reported that he would be testifying in front of this committee, and then at the last minute, it was reported that he would not be testifying, which I think is the right decision.
Right.
If I represented him at all, you don't want him testifying, especially if they're saying he potentially had autism and some other issues. That's not the issue. He doesn't need to testify. But there were multiple people that testified that made the case that this man does not need to be executed.
So is it testimony that maybe he needs a new trial or just life imprisonment?
No. I believe that the remedy is going to be potentially a new trial, right, given the new science.
Given a better understanding of this child's life and how this child may have died, including new science, it warrants a new trial.
Yes.
Is it common, and you mentioned earlier that Dr. Phil testified, John Grisham, who's an international author,
yep,
and a juror from the original trial testified. Is that common to have that level of celebrity and even your own jurors testify in your writ hearing or whatever hearing to decide your fate? Is that common?
I don't believe so, no. I think this case is going to be a landmark case.
So, in the end, what do you think, maybe not hope, but what do you think is going to happen with Mr. Robertson in his case?
I do think he'll get a new trial. I think there was so much evidence presented, and I only saw a portion of it. But there are multiple factors involved in this case and the stay, and I believe that this man needs a new trial. And based on watching the committee and the questions that they asked all of these witnesses, they appeared to be very open and receptive to the fact that this man did not need to be executed. That's just my opinion based on watching the hearing.
And I hope so. So if you could, I guess, carry what we've learned forward about Mr. Robertson, and not just about who he is, but and even ignore that part, about his case and what happened, what would you suggest to anybody listening in dealing with capital defense work, either legislatively or as a defense attorney or as a prosecutor, that can help us not potentially have a man serve 15 years or some period of time in prison for a crime he didn't commit, or at the very least is not guilty of?
So, since I've been doing capital defense, it's definitely been sort of like much more in my heart in terms of understanding the procedure and how people are getting convicted. I think one of the issues is that we need to have judges that are willing to pay for defense experts in these types of trials. There are sometimes some judges who don't want to pay for particular experts. I don't know why. It's not coming out of their pocket. It's paid for by the county. But when you're talking about the fact that the state's trying to actually execute a human being, my personal opinion is that a judge should grant any and all expert requests from defense counsel. Also, attorneys who are certified to do capital defense work, they need to be asking for anything and everything in terms of any potential experts to investigate the case, whether it be cell phones, whether it be mental health, medical records, psychiatric records, all sorts of things that maybe 10, 20 years ago were not readily available to capital defense attorneys. But I do think that that's a very, very big issue. And I have heard that there are some judges in the courthouse that are really not so willing to give money to defense attorneys. But in this particular type of case, you're talking about a death penalty capital case. That is something that needs to be readily available to any attorney who is on the capital list doing indigent defense work for capital defendants, because there's so much out there that the lawyer can't just go and investigate themselves. The lawyers aren't doctors. The lawyers cannot just go out and get all of this information because they're lawyers. They're not physicians. They're not mental health experts.
So Sylvia, you actually mentioned a few things I want to talk about. Like I said, this episode is going to deal a lot with capital defense work. And so I want to segue now from Mr. Robertson to, I guess, capital defense work in Harris County.
Okay.
All right. What does it take to first be an attorney, a defense attorney, approved to do capital defense work, indigent work in Harris County, Texas? Can anybody do it? Like any fresh out of law school student do it?
No.
You have to have trial experience. You have to be really cool, a lot of money. Like what does it take to get qualified to be on that list first?
It has nothing to do with money. You don't pay any sort of donation or anything like that. It has to do with qualifications and trial experience. You cannot do it fresh out of law school. You have to have a lot of trial work under your belt. You have to have recommendations from judges, colleagues, etc., who have known you, right? So I was a prosecutor for almost 14 years, and before I started doing defense work. So I had all the trial experience and everything, and then I've been doing criminal defense work for 14, 15 years. So
I don't want to throw a crazy number out there. We're talking about 28, 29 years of legal experience.
29, yes.
I'm only 30, so that's a lot of the legal experience.
Yeah, I'm old. I'm old.
So I'm going to take this step by step. I'm walking through here because I think it's important for people to understand when you talk about capital defense work, what it means to do it, and when you say you need money, why is that important? All right, so you mentioned trial experience. So we're talking about like misdemeanors, DWIs, we're talking about felonies, certain level of felonies.
Yep.
What kind of trial experience does one need to be approved to take capital defense work in Harris County, Texas?
I don't know that there's a specific number per se in terms of how many felony trials you need. For me, it was super easy because I had just been doing this for so long. Like I guess I'm almost old enough to be your birth mom.
Hey, Mom. Oh, by the way, Luke says, shout out, Ma. So shout out.
Hey, Luke.
There we go. Hey, Luke.
Hey, Luke.
All right.
Happy birthday.
So you've got the trial. So you've tried murders before.
Yes.
All right.
As a prosecutor and a defense attorney.
So one would need murder experience, first degree level experience.
Correct. And then you also need to, there's an application, and when you fill it out, you have to list people that they can contact on your behalf. And so there are multiple judges, other senior defense attorneys or prosecutors that you can list that can testify to, I've known this person for a long time and they know how to try a case. So
it's not enough for you just to say, hey, I tried a murder.
Correct.
I have to have somebody to say I tried a murder. Well,
probably multiple murders, not just one. One murder is not going to get you on the capital list, nor should it.
Right.
Nor should it. Sorry.
Okay. All right, so you've tried a few murder cases or multiple murder cases. Is there any educational requirement? Is there anything different from, let's say, a non-capital defense attorney versus yourself as far as education, moving forward? What would that be?
Well, also to be on the capital murder appointment list for indigent defense, you have to have a significant amount of capital CLE, and CLE is continuing legal education, and you have to have a significant number of dedicated, capital specific CLE hours to get on the list for appointments and then to remain on the list. And that is something you have to continue to do and submit.
So it's not enough, and if I'm wrong, let me know. It's not enough to just have criminal law CLEs or training,
Correct.
or even criminal defense CLE
Correct.
training. You need that. In addition to that, you need specific capital defense level training. Is that
It's
correct?
a whole different world. I mean, you can try 100 other cases, misdemeanors and felonies, but when you're talking about capital defense, it's the highest of the highest
Of the highest.
of the highest.
Gotcha.
And the law is very specific regarding capital prosecutions. And attorneys who don't practice capital litigation or capital defense don't know what it takes to pick a jury. They don't understand the special issues. They don't understand mitigation, which is very important in a capital case. There are very capital specific issues and laws and court cases that are not something that we look at when we're dealing with a regular murder or an aggravated robbery or sexual assault. Definitely not anything in the misdemeanor land. Right. It's just night and day.
So someone like yourself who does capital defense work, and you're approved for indigent work, you've gone through a certain amount of actual training as far as trial training and CLE training.
Yes.
All right. And then I asked you earlier, learning from the Robertson case and moving it forward, what would you like? And you said to have the judges approve your experts to properly litigate that case. When you go to trial in a murder or a capital murder case, are you saying the judges don't usually just approve your experts, or is it like you versus the state? What does that look like?
I personally have not had an issue with the judges approving my experts, but I have heard that certain judges are very hesitant to approve funding on certain experts in certain cases. So that's one thing. Another thing that I feel is the judges need to give the state and the defense appropriate time when to present the case to the jury, whether it's from jury selection to closing arguments. I don't feel that if a capital trial, really any trial, let's say it lasts 4 weeks, 6 weeks, 8 weeks, sometimes the judges they're like, you have 1 hour for closing argument, right? You don't know what the evidence is. Like, I don't want to be cut off. Like, if there's like volumes of technical evidence that need to be like explained again in summation, I don't want a judge to say, now you have to sit down, you've exceeded your 30-minute for closing argument or your 45 minutes for closing argument. Like, at that point, you risk flipping the case on appeal, right? It just doesn't make any sense, right? To then all of a sudden we're in a hurry to wrap this thing up. The case has been pending at this point on a capital case. The case has been pending for years. Years.
Okay, so this isn't like you get arrested tomorrow on a capital murder case. Tomorrow, let's say it's November 1st, 2024, and you're in trial March 1st, 2025. How much time between arrest and trial, in your opinion, is a typical capital murder death case?
At the state level?
At the state level.
Years. The discovery process is extremely lengthy. And when I say discovery process, obviously you know, but that's when under the Michael Morton Act, the state has the duty to get all of the evidence and turn it over to defense counsel. And this can be hundreds and hundreds of hours of discovery that a defense attorney needs to review.
And when they appoint you to, I hate to cut you off, and if you want to, just give me a second here.
You're good.
When they appoint you to a capital death case, is it just like Sylvia by herself? Is it Sylvia and like 30 attorneys? Is it like Sylvia in the DA's office with appellate? You have your own appellate staff, you have your own investigator staff, and you have 5 other attorneys with you. What does an appointment for a capital death case look like for a defense attorney?
So at a minimum, every capital case should have two lawyers. There's a first chair and a second chair, and those are two different appointment levels. Like we were talking earlier,
Right.
what it takes to get on the capital list. There's a second chair and there's a first chair. And so if you are first chair certified, that's an additional level of experience that you must have to be approved for the first chair list. You must have tried a death penalty case. You must have presented mitigation evidence, okay? So at a bare minimum, they're gonna have at least two attorneys. That's typical on a non-death capital. On a death capital case, typically you will also have appellate counsel that is approved to sit throughout the entire trial, potentially another attorney, and various experts. So
you can have a trial team of sorts.
Pardon?
You can have a trial team of sorts.
Yes.
All right. And then you also mentioned when you were talking that some judges seem to limit your ability to hire experts. What experts have you, or do you think you would need, or routine to need in a death penalty case? First question. Second question, why do you think a judge would not allow you to have an expert in the first place?
So when I said that sometimes the judges are holding back on funding experts, I have seen that more on non-death penalty cases, okay? On a death penalty case, you really want any kind of expert that you can get. You want a mitigation expert. You want so you want a factual investigator. You want a mitigation investigator, potentially a mental health investigator, psychiatrist, doctor, examination, all of those things. If your client might have any history of mental health issues, not all of them do, but if they do, these days we have cell phone data, right? Something that didn't exist back when I was in high school. But now,
the
1980s. But now, everyone has a cell phone.
All right.
And the cell phone has a ton of data on it, whether it's your text messages, your phone calls, your location, your photos, your Instagram, your Snapchat, your Facebook, your emails, right? And that, if you ever look at what they call a cell phone extraction, on one phone, thousands of pages of documents just from my cell phone. Okay? So you need an expert to sort through that. There is specific software, namely Celebrite and things like that, that are used to go through and examine a person's cell phone. And in like some of the capital cases that I have handled, we have five different cell phones. Cell phones from the victim, cell phones from the suspect, cell phones from witnesses. And it's like thousands and thousands and thousands of pages.
And this is all important in a capital case. One, because you're dealing with life without parole. And then in a capital death, you're dealing with a person's life.
Yes.
Right? And the mindset kind of is, if you're going to either A, put somebody in prison for the rest of their life.
Without parole.
So they're going to live and die in prison.
Right.
Or B, you're going to strap them to a gurney, put needles in their arm, and kill them.
Right.
You want to be certain, right? And I think we can all agree in every conviction, be it a Class B misdemeanor or capital death, you want to be certain you got the right guy.
Yeah.
But humanistically, we understand you could come back from a Class B misdemeanor. You can't come back from death if we've killed you.
Correct.
So it would seem prudent that before you sanction a person to be killed by the state, that everything's been exhausted. Would you agree?
Everything. Everything needs to be exhausted. And I think now what we have in terms of technology and evidence, DNA has progressed in the last 10, 20 years. Cell phone technology has progressed in the last 10, 20 years. All sorts of evidence has been, the science that we have now is not something that was available to us 20 years ago.
So actually, I want hold on to that because I want to come back to that point. But I will say, so then it sounds like you would need experts not just in investigation and mitigation and
Right.
mental health, but potentially cell phones. If there is DNA, which there always is DNA,
Yep.
and then any other case-specific stuff, like in Mr. Robertson's case, shaken baby syndrome, right? And so you would need something like that, or accident reconstruction,
Yes.
or some sort of like, I guess, shot diagram to see where bullets are flying.
Firearms. Oh,
Firearms.
I had a very complicated capital murder case this year, and it was the most complex firearms crime scene that I have ever seen.
Okay.
More than 5 or 6 different firearms at the scene. There were 3 dead bodies. There were, my client was charged. There were other people involved, and like you said, the bullets were flying everywhere. And, even if you're a defense lawyer who understands firearms, it is absolutely overwhelming to lay that out, and the defense attorney cannot testify
Thank you.
to their findings.
Just gonna go there. You got me for it. I was just gonna say, like, as if you understand that as an attorney, what can you do with it if you can't testify?
You can't. So you need to file a motion and ask the judge to appoint you a firearms examiner, right? And obviously, first, the defense attorney has to find a good firearms examiner. And they're not always just sitting here down the road in Houston. Like, sometimes you have to pull them from further in other parts of the state, sometimes outside the state. And we had to find somebody who was top notch to go through this firearms reports. It was
It's a lot of work.
extremely confusing. And we had multiple meetings with our firearms examiner. And that's not always going to be an issue in every case, but in this particular case, it was huge. It was huge to determine, who was firing, which guns were fired, and, because all of these people were.
So someone like yourself who is qualified, when you ask for experts, you're not just asking for everything you could possibly get. You're being specific to what you need for this case. Is that correct?
It's different for every case.
Every case is different.
Yes.
That's alone. Now, we have to ask for experts as defense attorneys. Mm-hmm. Does the state have to ask for experts?
No.
So if a state has DNA and ballistics, let's just throw in somehow a shaken baby is involved as well. What do they have to do to get an expert to testify on their behalf?
Not much. The state has all of the resources, all of the backing. They don't have to ever ask for money, except for, maybe if they're, I remember when I was a prosecutor, like if you had to fly in a witness from out of town, you had to get that approved through the DA's office to pay for that flight.
So travel expense.
Right. But the state has unlimited resources when it comes to their cases. So usually when they're building their case, they have all of this, they're just all lined up. That's part of their investigation. But if we want to build our case, every time we need an expert witness, we have to file a separate motion explaining the need of this particular expert, and ask for funds.
In a capital defense in a capital murder prosecution, the state can marshal any expert they desire, no matter how important or germane or tangential it might be, to just whatever. But you have to ask for permission and get approval and get finances and that kind of thing. Is that correct?
Yes. And it is quite tedious.
It's quite tedious.
And then you have to get them paid, right? You have to file the motions, you have to approach the judge, you have to get their invoices, you have to get them paid. It is so much extra work for a defense attorney, but that's what you have to do.
So if I can just kind of, boil it down, Sylvia, you get a death penalty case. Not only do you have to review the discovery and go through that kind of stuff, you also have to become like president, CEO of the defense team for this particular person. You got to do the hiring, the firing, the recruiting, the managing, the review, all that stuff, all as one. Yeah. Right?
Yes.
Right. And that's a lot of work for one attorney.
Well, that's why there's always 2, at least.
Good. And so all that is involved in just one capital defense death penalty litigation.
Yes.
Now, We're going to bring it back to Robertson, and then we're going to move to Goings in a second. So back to Robertson, you mentioned earlier that you would like the judges to approve funding or to not limit it. Why is funding that request? Why, of everything we request for, why funding for the experts, why is that the number one request?
You cannot defend somebody without appropriate experts that are knowledgeable in fields that are extremely important to a defendant's case. I mean, I'm a lawyer. I'm a great lawyer. I'm not a doctor. I'm not a DNA expert. I'm not a firearms expert. I'm not an investigator. I'm not a mitigation expert. Like,
And all those things you need in your team.
yeah.
And they all cost money.
Well, they do, because most people aren't going to do it for free.
Nobody works for free.
No.
Nobody works for free.
We don't work for a lot, but in terms of the experts, they need to get paid.
You gotta get paid.
Yes.
All right, so let's switch. Let's move off of defense work and let's go to Goings. You know the Goings case?
Yes.
Yes. All right. Are you familiar with the Goings case?
Yes, Gerald Goings?
Yes, Mr. Gerald Goings.
Let's
All right.
talk about it.
Let's talk about Goings. We got 10 minutes left, and
Okay.
and I will be honest to say I have mixed feelings about Mr. Goings in this case.
Okay, what are your feelings?
So my first feeling is this: I don't like dirty cops.
I don't either.
Right, and that kind of perverts the system, in my opinion.
Absolutely.
We're supposed to trust them to do the right thing, and he absolutely perverted the system. So first, let's talk about how he perverted the system, and then let's go into how his trial and why I think he's getting a new trial. Anyway, so
You think he's going to get a new trial?
Oh, absolutely.
Okay.
Absolutely. That's the defense attorney side of me, the side of me that understands how to look at the cases and litigate it and analyze it. So Mr. Goings, Gerald Goings, wasn't as an officer of HPD, correct?
Yes.
All right.
Narcotics.
Narcotics. In a very, if we can be very brief, how did he pervert the system?
Briefly?
Briefly. I know it's hard. 'Cause
Briefly,
he did it for a long time, but how?
He lied in a affidavit to force entry into the Tuttle's home. Right. He claimed that there was narcotics sales going on there. That was not true. He lied in the affidavit saying that he had a confidential informant that was backing all of this.
Not true.
That was not true either.
Right.
And as a result, when his narcotics team executed the search warrant on this house, the no-knock warrant, and they went in, obviously gunshots were fired, multiple people were shot, multiple people were, 2 people were killed, including the dog.
The dog. So let's break that down. Like I said, we got 10 minutes, but very brief. All right. You mentioned, first of all, an affidavit for a search warrant. What does that mean?
Well, that was the tampering with evidence case.
Okay.
And we have never in Harris County seen a murder under this specific legal structure, which perhaps is where you're going with why you think he might get a new trial. I think it's a case of first impression. So typically a murder case is when you intentionally or knowingly intend to kill somebody or commit an act clearly dangerous to human life, right? But there's a different way to commit murder under the Texas law, and that's a felony murder statute. Okay. And I believe that Gerald Goings was prosecuted under the felony murder statute. Is that what you think?
That's what he was. And the felony murder, what does it mean? Because you kind of tied that in with, we talk about capital offense and committing aggravated robbery.
Yep.
What is felony murder rule?
Well, that's when, in the commission of another felony, you intentionally or knowingly, commit this murder, right?
Now, when we say it committing the felony, this is why Goings to me is so wild. Does it have to be like a dangerous felony? Like you said, ag robbery for capital murder.
Correct.
Does it have to be ag robberies or kidnappings? Is what you said, or can it be like anything?
We have never seen somebody prosecuted for murder under the felony murder statute with an underlying non-aggravated offense, such as tampering with a government document, and I believe that's the indictment.
Yep.
Right. So typically it's in the course of something else, like aggravated robbery, some sort of other aggravated offense. But a felony murder, and we do see it, sometimes they overcharge with these DWI cases, right? In the commission of a DWI third offense, which is a felony. But this particular case, the Gerald Goings case, we've never seen anybody, whether a police officer or not, charged with felony murder with the underlying offense being a tampering with government document. It will be very interesting to see what the Court of Appeals does with this, because I believe it's a case of first impression.
I think it's why I get overturned. So when we talk about felony murder, typically you talk about a underlying felony that's inherent to human life. Aggravated robbery, we can all agree, is inherent to human. It's dangerous to human life.
Yep.
Like you rob somebody with a gun, they might die. You might shoot them.
Right.
We understood it. Even with a DWI third, which I do not agree with, I can kind of get the logic. You're driving drunk, you hit a car, a passenger or somebody, they might die. I don't agree with that logic, but I understand it.
Sure.
Tampering with a government record is like a state jail or third-degree felony, correct? Like in the history of mankind, up until Goings, in Harris County, Texas, no one has died from tampering with a government record.
Right.
Right? And that's what I think.
Not to my knowledge.
Not to my knowledge. That's kind of a thing. Basically, the argument is he lied on an affidavit, and because he lied on an affidavit, it led to a search warrant being granted, which led to a SWAT team doing a search, and then you said no-knock, which I want to get to in a second, a no-knock search warrant,
Yep.
which happened, and as a result of the no-knock search warrant, the people living in the house didn't know what was going on and fired shots at people breaking into their home, and then the cops fired back, and then everybody's dead. The two people on the house, the Tuttles, their dog Tuttle, and I think one cop was shot, but like
Multiple cops were shot.
most shot, but nobody was.
Gerald Goins was shot in the face, and there were several other officers that received
They were shot.
Yes.
But no cops died, just the Tuttles and their dog.
Right.
All right. So and I think me personally as a defense attorney, even though I think Mr. Goins was a dirty cop,
Yes.
and I'm not at all upset he's in jail or prison for what he's done. The idea that tampering with a government record can lead to a murder charge is wild to me.
I agree with you, Damon. I do. He's a dirty cop. People hate dirty cops. I think that was clearly evident in the jury's very fast guilty verdict in this case.
It's a 3-week trial. It was a capital murder trial that was a capital murder.
Right.
And then he got 60 years and no time at all.
I mean, yeah. I mean, they were out for a few hours, and it was a very, very quick verdict. And that's because people do not like dirty cops. And what he did, because of what he did, the Tuttles would be alive if he had not lied on that search warrant.
Right.
So I do understand that. But because of the unique legal issues, the way that the indictment was in this particular case, it's a stretch. It's definitely a stretch.
And
We've
from
never
your
seen
experience as a 14-year prosecutor, a 15-year defense attorney, when you see indictments and jury charges that are a stretch, that usually means issue. Like it usually means a problematic situation, correct?
Yes.
And when it's a stretch and problematic, it's like, okay, that means something is wrong here.
Yeah.
It's like an overreach.
Right.
And I definitely think the Tuttles deserve justice.
Yes.
I really do. And I definitely believe that Mr. Goings is where he's supposed to be.
I agree.
Like he should be in prison.
No, I agree.
I just don't believe that what they charged and how they got him, I personally don't believe it was there. What do you think?
No, I agree with you, Damon. It's just, it's going to set precedents, right? If this stands up on appeal,
Yeah.
then it's definitely precedent case. I mean, going forward, right? It changes everything. I do think the DA overreached, but I can totally understand why the jury rendered its verdict. And then, and then the punishment evidence was horrible, which is a whole other issue.
Yeah.
But so, yes, I think everybody wanted to see a dirty cop be punished and prosecuted because of these innocent people who were killed, right? Mm-hmm. And so they're creating new law.
Right. And in my opinion, the law they're creating is dangerous law.
It is.
It's slippery slope law.
It is.
If you can take a tampering with a government record and somehow stretch it to a felony murder,
Right.
I just that seems to me to be like a place where we don't want to be, and making any felony, even the ones that aren't, that's like taking a forgery and which is a state jail felony, and somehow making a person guilty
Right.
and getting 60 years of prison for forgery. It's like, wow, you know? It's like, wow.
Right.
And that's a lot of the things that have to happen to make this work, and I just don't think that that's legally sufficient.
And it may not be. I think this case was fact specific and very unique. The fact that not only did he lie on this warrant, he then commanded his entire narcotics team to go in guns blazing. So that is different than me writing a forged check to you.
Correct.
Right?
And then me having a heart attack and dying, and all of a sudden I'm charged with capital murder. It's like, I mean, felony murder. It's like, whoa, you know.
Right, but if we're just looking at the four corners of the indictment, I don't know that we get there. But I do understand factually how we got there, like why they tried this prosecution. As a defense attorney, I would agree with you,
Weak.
saying that this is really bad precedent and this is not going to be legally sufficient. But I do understand why they proceeded to try him this way, because they were trying very hard to get some sort of justice for the Tuttles. Definitely it's a civil case.
Sylvia, I'm going to cut you off because we're running low, and you get the last word. So look at the camera. I don't know which one we're at. Say your last bit because we're about to go.
No, that's it.
That's it?
I don't know what else to say. I mean, I do think that it was, it'll be interesting to see what the Court of Appeals does with this, and potentially the Texas Supreme Court, because it's a case of first impression. But people,
I got to wrap up now. We're closing.
Thanks,
so
David.
it's another
Thanks for having
episode
me.
of Reasonable Doubt. Sylvia, thanks for being on.
Thanks for having me.
We could have talked for two whole hours about
Yes,
everything we talked
we
about.
could have.
Luke, see you, man. Wave. My man.
Love you, Luke.
Love you, Luke. All right, my kids, everybody have a good night.